session in this Future 50 Casino Expo. This session is going to be estate planning, ensuring a smooth transition for your loved ones. We have with us Deanna DeCosimo, Esquire of DeCosimo Law, and we're so happy to have her here. Ladies and gentlemen, please welcome Deanna DeCosimo.
Yeah. Woo!
Can you hear me okay? Okay. So yes, I'm Deanna DeCosimo with DeCosimo Law. I'm an estate planning attorney in California. And I am physically located in Temecula, but I am a mobile attorney and a virtual attorney. So I will meet my clients where they're at. And there's also the option to meet virtually on Zoom if people prefer that. In today's presentation, I'm going to do things a little bit differently. Instead of the more traditional sort of estate planning presentation, I'm going to do it more like a story, like a before and after story. And we don't have too much time, so I'm not going to get too deep into anything, but please feel free to stop by my table afterwards if you have questions, or to send me an email or give me a call. So let's get started. Okay, so today we're going to meet the Bliss family. So this is Mary and John. They've been married for 50 years, and they have 2 adult children, Denise and Richard. And unfortunately, John passed away 10 years ago. They bought a house when they got married for $50,000. This is Richard, is a successful businessman. And this is their daughter, Denise, and her 7-year-old daughter, Jenny. And Denise is a single mom. So Mary lives with her daughter and her granddaughter. And Mary is always concerned about, when she passes away, what's going to happen to her daughter and her granddaughter. She wants to make sure that they're always going to have a home to live in. So she decides, why not gift the house to my daughter while I'm still alive? We live together anyway, so it would just be simpler to just gift her the house while I'm still alive. Mary also decides, because she's getting older and she's having a hard time, getting to the bank and handling her finances. So she decides to add her daughter Denise to the bank account. That way Denise can just go to the bank and get money for her. And then she also wants to leave an inheritance for her granddaughter. So she changes the beneficiary on her life insurance policy for $150,000 to her granddaughter. And then eventually Mary passes away. Mary did have a will, and in her will she said she was going to leave everything to her 2 children 50-50, so equal shares to Denise and Richard. And her will, she just prepared herself by finding a template online. She thought, it's not a big deal, I don't need to see a lawyer because I'm just splitting my assets equally between my 2 children. So when Mary passes away, these are her assets. She has $150,000 in the life insurance policy. She has about $800,000 in retirement accounts and $50,000 in her bank account. And remember, she already gave the house away to Denise. So who gets what? Well, the $150,000, because it's being left to a minor. Remember, Jenny was only 7 years old. Let's say she's 10 when Mary passes away. Because she's under 18, they need to go to probate court. So a judge can decide who's going to manage that money until Jenny turns 18. And then at that point, Jenny's going to get all the money outright at 18 years old. The $800,000 in retirement accounts, well, Mary never changed the beneficiary, so she had her late husband, John, as the primary. She had her daughter, Denise, as the secondary, and then underneath that, Richard. And it's very likely that she didn't mean to have it set up like that. I have a lot of clients who come to my office who actually want to put their spouse as the primary and all of their children as the secondary and equal shares. But they don't realize that they might list them second, third, fourth. So in this case, Richard's not going to get anything from the retirement account unless both John and Denise have passed away. And the $50,000 in the bank account, Well, because Mary added Denise to that account, it's now a joint account, which means that money is Mary's. I'm sorry, it's Denise's. So that might not have been what she wanted either. So what does Richard get? He gets nothing. And I'm sure that was not Mary's intentions. And unfortunately, this happens way too often where people accidentally disinherit their children or other loved ones. What people a lot of times don't realize is that a pay-on-death beneficiary trumps what your will says. Also, if you have a joint account with right of survivorship, it's going to go to the surviving joint owner, regardless of what your will or trust says. Right now, this is going on in my own family, in another state. I had nothing to do with the estate planning, but my great uncle, he was very proud of his plan. He told all my family members how much inheritance they were all getting. And unfortunately, when he passed away, obviously everyone was very sad, but they were also surprised to find out they weren't getting anything because all of his assets were in retirement accounts, investment accounts, bank accounts with either his spouse as the joint owner or with named beneficiaries. So there was no money for all the gifts that he made in his will. So just something to be aware of. And now let's say Denise wants to sell the house. So remember, Mary gave the house to Denise while Mary was still alive. So now, when Denise goes to sell the house, she's not going to get what's called a step up in basis. So the basis, the cost basis of the house is going to be based on the value of the house when her father died. So they bought the house for $50,000. When her dad died, the house was worth $500,000. When her mom dies, let's say the house is worth $1 million. Well, we're going to base it off that $500,000. So Denise is going to have to pay capital gains taxes, the difference between $1 million and $500,000. There is a $250,000 possible exemption here. We're not going to get into all these details, but just know she's going to have to pay capital gains taxes. So what about this instead? Let's say instead, Mary did not give her home to Denise while she was alive, but she instead just left it in the will, again, 50-50 to her 2 children. Instead of adding her daughter to her bank account, she set up a power of attorney, named her daughter as the agent. That way Denise could handle her financial affairs, but Mary would still own all of the money and all of her assets. So again, Mary passes away, but this time, the house is going to get that step up in basis. So if Denise and Richard decide to sell the house, they're not going to have to worry about capital gains taxes. So the differentiator here is because when you leave your home to somebody in your will or your trust or after you pass away, it gets that step up in basis. If you give it away to them while you're still alive, it doesn't. But before they can sell the house, again, they have to go to probate court. So not only is it going to have to be probate for a minor getting the $150,000, but also here because there is the home in the probate estate. And why don't we like probate in California? It takes a long time and it's expensive. So on average, it's about 5% of the fair market value of your estate. So in this case, the only asset in the estate, in the probate estate, is valued at $1 million. And even if there's a mortgage on this home, even if they have $1 in equity, it's based on the fair market value. So probate's gonna cost about $50,000. And this could have been avoided. And also probate is public. So how do you avoid probate? By setting up a living trust. So think of this wagon as the trust. And think of the toys in the wagon as your assets. As long as you have a living trust and it is funded, that's the important part here, is that it's funded, meaning your assets are actually in the trust, probate will be avoided. A lot of times if you do it yourself, your estate plan, or maybe work with a trust mill, some of these attorneys, they don't make sure that you fund your trust. They will sell you a stack of papers that are going to be useless if you don't fund your trust. So it's super important to remember you need to fund your trust. You need to change the title of your home to the name of your trust. You need to change your investment accounts, your bank accounts into your trust. you need to change your beneficiaries of your life insurance, of your retirement accounts, to the name of your trust. So now let's say Mary had set up a living trust. Now there's no probate court. Her estate plan is going to be completely private, so no one's going to know what she had when she passed away and who's getting what. And the assets would be available immediately. So this is what I had mentioned before. For these accounts, you could change the name of the pay on death beneficiary. You could actually put your bank, you could change the title of your bank too, like your bank could be owned by the trust. And in this situation, Mary could have, had her trust say she wants $150,000 to go to her granddaughter, but to be held in trust until Jenny turns whatever age she wants. She can say, I want Jenny to get 1/3 at 22, 1/3 at 25, the remaining third at 30, or however she wants. She could also say, I want it to stay in trust for Jenny for her lifetime. And then whatever is left over, minus the $150,000, would be split evenly between Richard and Denise. But there's one more issue that you need to be aware of, and that is Proposition 19. And I don't have a lot of time today to get into the details about Proposition 19, but it is something to be aware of, and it has to do with property taxes. So let's say the house is now left to Denise and Richard, 50-50, but Denise wants to stay in the house, and Richard wants to be bought out. Well, under Proposition 19, a sibling-to-sibling buyout will cause a partial tax reassessment, property tax reassessment, which means Denise is going to have to pay higher property taxes than her mom was paying. And in California, that could be very significant. Because remember, they bought the house for $50,000, so their property taxes are really low. So there are ways to avoid that happening, that partial tax reassessment. So if you are thinking to leave a home to multiple children, I definitely suggest that you talk to an attorney. You're probably going to want to set up a living trust and have the right language in there to make sure that the property taxes don't get increased. Quickly too, as I mentioned, federal estate taxes. Most people don't need to worry about that. The current exemption is about $13 million. It used to be much lower. So if you had your trust designed more than 5 years ago, and especially more than 10 years ago, please have it reviewed by an estate planning attorney. It's very likely that you might have what is called an AB or an ABC trust. These were very popular 10 years ago, even longer, because estate tax exemptions used to be much lower, and estate taxes are about 40% or higher over the exemption amount. So these AB and ABC trusts were very popular to avoid federal estate taxes. But now, because the current exemption is nearly $13 million, the average person doesn't need to worry about this. What they need to worry about is their family members having to pay capital gains taxes. So again, if you have a trust, have it reviewed. So the takeaways that I hope you take from this presentation are a review of all your assets must be part of your estate planning conversation. Just one document, just setting up a will, is not going to get your desired outcomes for your loved ones. It's really important that all of your assets are looked at. Poor planning may cause your family to pay capital gains taxes and have their property taxes increased. It's actually easier than you think to accidentally disinherit your loved ones. And again, have your estate plan reviewed by an attorney. And if you don't have one, you should really think about getting one in place. So I am, again, Deanna DeCosmo. This is my law firm. I only charge flat fees agreed upon in advance, so you'll never get any surprises. I focus on building relationships with my clients. Every plan I do is custom for my clients' unique needs. I don't just, use a template, same plan for everybody who comes into my office. And I review the plan every 3 years at no additional cost. There's a 3-step process. We'll meet first for a family wealth planning session. During that session, the first half will be reviewing some homework that you did in preparation, where you're just going to kind of let me know what your values are, what's important, Why are you thinking about estate planning now? What assets do you own? We'll go over that, decide if you want to change however things, I will tell you, based on what you have right now, if you pass away tomorrow, this is what's gonna happen. Is that what you want to happen? If not, well, let's go ahead and design a plan that's gonna give you the desired outcomes that you want. About 4 weeks later, your documents will be ready. You'll have the signing ceremony, you'll have everything notarized and witnessed, and then about 4 weeks later, you'll receive your binder with all of the documents. We can set up a meeting with your family if you want to explain it, go over the plan with them. And also you can record a video for your loved ones. And today, just to incentivize you to take action, I'm offering $250 off a plan if you book a family wealth planning session with me after this presentation. Again, there's absolutely no obligation, there's no cost, we'll just go over that homework. It'll be more of an educational meeting, and then it's up to you if you want to proceed with designing a plan. If you have any questions, my email is here. You can come to my table. I know the event is ending soon, but I would love to talk to you. And I know we still have a few minutes for questions. 602.
One question.
Yeah.
I accumulated all my assets before marrying my Swedish husband.
Okay.
Do you need to let him show to your office that if he is not actually included at all, is inheriting them?
So that would be your separate property as long as you didn't commingle your property. I don't do family law, so I can't get too much into that. But if you were to come to my office with your husband and wanted to do any sort of joint planning, I would not be able to hide anything from your husband. But if you just wanted to come in strictly based on your own separate property, then we could keep it private from him. But it's also important, you don't need to answer this question now, but citizenship status does matter too when you're leaving assets for a loved one, so we could talk more about that.
So how much is your
So a trust plan starts at $2,000. If you're looking for a will, it starts at $700. Will is included in the trust. So every package, regardless if you get a will or a trust, also includes an advanced healthcare directive, power of attorney, HIPAA release, if you have small children, guardian nominations, short-term and long-term. I prepare all of the letters to your fiduciaries. I change the title to your home. I give you a funding toolkit to help you change all of your other assets, put them into the trust, and I'll be there to hold your hand for all of that. I said every 3 years, I'll review your plan at no additional cost. If you have small children, I'll give you ID cards you can leave in your wallet. In case of an emergency, people know you have small children at home, and it will say who to call in what order. So it's a big, comprehensive plan.
I live in Georgia.
Okay.
You guys did find an attorney in Georgia.
Yeah, I'm only licensed in California.
Different process.
Yeah, correct.
Where did you say your office?
So I mostly work virtually or mobile. So I'm physically in Temecula, but I go to my clients. I go all the way to LA County, but I also meet with clients on Zoom if they prefer.
I have a question regarding your will. If you do a will, I hear what you're saying, it has to go to probate. But what if you only have one person you were leaving it to? Does it still have to go to court?
It depends. So if the estate is under, I don't remember the exact amount, I want to say around $180,000, there's a small estate affidavit where you can avoid probate court.
There'll be a house, so it's a house. So it's
A house, okay. If it's owned with the community property with right of survivorship or joint tenants with right of survivorship, it would just go automatically to the other, the survivor. But if you both pass away at the same time, then there's going to be probate. So you probably wouldn't want to transfer anything to him now while you're alive. You'd want to wait leave it to him in your trust, say when you pass away it would go to him. Otherwise, you're gonna have to pay he's gonna have to pay capital gains taxes if he sells the property. He's not gonna get the step up in basis. If you gift the house to him while you're still alive, when he goes to sell it, he's gonna have to pay capital gains tax based on whatever price you bought it for. Okay, I think we're probably out of time, but like I said, please stop